The government's agenda was to get those, protect those documents and get them out. And I think it was perfectly appropriate to do that. It was the right thing to do. And I think the counts under the Espionage Act that he willfully retained those documents are solid counts. Now, I do think we have to wait and see what the defense says and what proves to be true. But I do think that even half what Andy McCarthy said, which is if even half of it is true, then he's toast.
The he's toast part was what you needed to see before we tell you about this next story. Hi again, everyone. It's 5 o'clock in New York. An update today in the criminal case against Donald Trump over the hoarding of national defense information and classified documents, where Donald Trump's own former Attorney General Bill Barr believes he is toast. The judge in this case, Trump-nominated Judge Aileen Cannon, has rejected the effort by Trump to push the trial past the 2024 presidential election for now. In a new filing, Judge Cannon said the May 20th, 2024 date she set back in July would stay. Again, for now. Our colleague Lisa Rubin describes Cannon's order as one that, quote, cemented her role as the Lucy with the football of the federal judiciary, because although Cannon did not push the trial date back, she did leave open the chance of doing so when both sides meet on March 1st. In her order, Judge Cannon did push back several pre-trial deadlines and acknowledged the unprecedented volume of discovery in this case that is complicated by its classified nature. Meanwhile, new reporting from CNN sheds light on potential witnesses that the prosecution may call in this case whenever it does go to trial. That reporting says that in addition to those closest to Trump, valuable witnesses may include low-level staffers at Mar-a-Lago, including a plumber, a maid, a chauffeur, and a woodworker. From CNN's reporting, quote, other likely witnesses also include Trump's Secret Service agents, former intelligence officials, as well as people who were in the room with Trump when he was captured on multiple audio recordings referencing a military document about a potential plan to bomb Iran. That's according to sources familiar with it. But the low-level workers who were the eyes and ears of Mar-a-Lago, if called to testify, could offer the public a new level of insight into the exclusive club and Trump's approach to sensitive national security information since he left office. Some of them are still employed at Mar-a-Lago. Trump, obviously angered by the reporting, he criticized CNN and the special counsel, but then confirmed the details by saying, quote, of course, various people saw paper and boxes at his Florida club. He then falsely argued that he had the right to have that material under the Presidential Records Act, which isn't a thing, which gave him that right. It's where we start the hour with some of our favorite experts and friends. Former Deputy Assistant Attorney General and former U.S. Attorney Harry Litman is back, plus former Acting Assistant Attorney General for National Security at the U.S. Department of Justice, Mary McCord, is here. Also joining us, former top national security official of the Department of Justice, Brandon Van Grack. As I read all of your titles, I hope that you all, I'm grateful to have all of you to talk to about this. I hope that you someday are back in there because it feels like we're going to need it. I feel like with this case, I'm always reminded of Donald Trump's indifference to U.S. national security. And I wonder, Brandon, if you're worried about that and you also are plugged into the political calendar, should we be worried that the judge has done something that makes it more likely that she will ultimately push this trial back?
I think it is very fair to say that it is unlikely this trial will now happen on May 20th, even though the judge has technically preserved that date. If you look at the order and the deadlines and even the language in there, it seems very unlikely. I'll say it's possible, but it's unlikely. The deadlines were shifted anywhere from a month to 3 months from where they were originally. There are even some hearings and filings that are necessary that the judge didn't even schedule, which signals that even this now prolonged time frame, the judge has concerns that it'll be met. And on top of that, the deadlines between the filings and hearings, they're really nice cushions. They're sort of longer when they need to be. So it suggests that even after we get to these hearings, it's sort of unlikely that we're going to see this judge ramp things up.
And Brandon, what do you do about that?
Well, first thing is it is not unusual or unheard of for a judge to choose a deadline that one or both parties don't agree with. And so part of this is you adhere to that schedule. I think you're going to see the Department of Justice do everything they can to adhere to it and continue to convince this judge that even under this timeline, they can still meet that May 20th deadline, which I think is true. It's possible. But I do think that there's one sort of particular point in here, which is some of the judge's rulings already are going to make it complicated, are going to make it difficult. She sort of turned classified discovery, the process, a little bit up on its head, and it's going to take a little bit more time for the Department of Justice to handle it.
And Mary, what is the consequence of this trial perhaps getting pushed out?
Well, obviously that could have an impact on other trials because right now we don't know when Fani Willis in Georgia will schedule the next trial. It's interesting to me that in that case, the judge hasn't, at least so far as I know, hasn't ask her, when is the date that you want to go to trial against Mr. Trump and the remaining defendants? But by maintaining this May 20th trial date, by Judge Cannon maintaining it, that date is sort of off the table for Fani Willis. Yet, as Brandon just indicated, given the schedule that Judge Cannon has now set for so many of the pretrial proceedings and SIPA proceedings that have to take place before they can even think about, starting the trial, it seems highly likely that May 20 date will not remain. Yet, will it become available, too late for Fani Willis to potentially slot her trial in there? So, there's this sort of domino effect with the various trials. The other possibility, of course, is that this won't get tried at all before the election, and I'd say that's fairly likely. I mean, one of the things interesting about the way Judge Cannon wrote this order is, I will say I felt like she was bending over backwards a little bit to sort of not cast blame on any of the parties, including Jack Smith and his team. And sometimes she's been pretty quick to cast blame on Jack Smith. She didn't really do that here. She blamed things on just the voluminousness of the discovery, including the classified materials, and what she says is going to be a more significant than anticipated SIPA Section 4 hearing. And this is a hearing where the government can come to the court. It's ex parte, defense and defense counsel are not there, and say to the court, here are things we want to keep out of the discovery, and because we either don't think that they're actually relevant and need to be turned over, or because they're so sensitive, we want to redact them or create substitutions. These are things that she's going to have to rule on herself. She's going to have to read all of these materials, have argument, make assessments, and I think she's frankly trying to leave herself a lot of space to do that, which is another reason I agree with Brandon that I just don't think this trial date of May 20th is going to hold.
Harry, let me read a little bit more from Judge Cannon's filing. She writes, fourth, although less important at this stage, the court cannot ignore the realities of pretrial and trial schedules in two other criminal matters identified by defense counsel. Although the special counsel is correct that the trajectory of these matters potentially remains in flux, the schedules as they currently stand overlap substantially with the deadlines in this case, presenting additional challenges to ensuring defendant Trump has adequate time to prepare for trial and to assist in his defense. I read the special counsel's filing on this, and they seem to articulate the opposite, right, that there was plenty of time to do both. Is it also fair to read Cannon as more sympathetic to Trump's voluminous alleged crimes against him?
100%. It's an order that the more you look at it, the more problematic it seems. In particular, to your point, Nicole, if you go back to what the government had to say, they gave many reasons that Trump's arguments for a continuance didn't fly, that, in fact, it's not so much discovery. In fact, the government has provided more than it's supposed to. Cannon ignored those altogether in a sort of 5-page, really one-sided summary up top. And that was, one sign, as you read it more closely, that it's going exactly where Mary and Brandon say. And then notice the very end of the point you cited, which is she's suggesting a due process claim, not a simply how much time do you need. She's suggesting that when the time comes, she's going to say that Trump's constitutional rights would be abridged if he doesn't get this sort of enormous delay. And one more point, what Mary said, it is a complicated complicated notion, but here's a way of simplifying it. On the Section 4 skirmish that will happen, before there was a week between the procedure that Mary outlined and the hearing. Now it's something like 7 weeks. It really suggests she is ready to adopt a very novel procedure that Trump is asking for, to take what should be an ex parte, or just between the government and the court process, and make it adversary. So in many ways, the more you read it, the more it seems like a very pro-Trump order camouflaged, which is a problem in and of itself, right? Camouflaged as a neutral order.